Good
Can you hear
morning.
me?
Good morning. Yes, I can. Can you hear me?
Yes, we can hear you loud and clear. I would like to say good morning to everyone and apologies for a little bit of a delay. John, don't worry. We all know it's silly season in the test industry at the moment. As I'm sitting now on my way driving to a meeting, that's why my camera is off. So we don't have a problem with you being late a little bit. It's a real pleasure for me to welcome all of you for today's session with the webinar, and a warm welcome to the TESD members and also the members of the CEI Exco that is in the meeting, and then my colleagues and the fellow Exco members from the TESD. It's fantastic to see so many of you here today. Not so much as we have previously, but I'm excited for the discussions that John is going to dive into today. And with that, I'm delighted to introduce today's speaker, our well-known, I wait for the drum roll, John Buerta, who has been in the forefront of compliance issues in the TES and will help us to uncover those overlooked areas in our business to make sure that we don't break our business with non-compliance. And John will unpack critical issues in the test space regarding compliance specifically. Are you confident of your test operation, and is it fully compliant with all applicable labor laws? I have to apologize in that I will not be able to participate to the end of this webinar due to other commitments, and Kevin will close off the webinar for us today. The benefit of this webinar and being recorded is that at the end of the webinar, Krista will then send this out to all the members. So those of us who are in a hurry who won't be able to attend maybe the full webinar or at all, they can look at it at the beach, maybe when they're on holiday in December or whenever they have time, because I think this is real something that is important to ensure that we stay within compliance in our industry. And with all that, John, the floor is yours.
Thank you so much, Lisa. I appreciate that. And good morning to all of you. I was just looking at all the colleagues on the call, and some familiar names and some less familiar names, but I do trust that you will all get benefit from today's session. Again, my apologies. I just had to open a conference and just give the opening pitch. But of course, it's an absolute pleasure to be with you. We've spent pretty much most of the year together running these sessions virtually on a monthly basis. And, you know, we've covered very interesting topics, colleagues. We've covered topics in terms of the core labor law developments in the country. We've covered emotional intelligence. We've covered digital intelligence. We've looked at different models and workforce models that companies should be using. And of course, right now, there's a massive, massive drive in terms of platform workers and how to structure platform workers. So we are not in a boring environment. We are in a very, very volatile and uncertain, complex and ambiguous environment. So the objective of these sessions have not been to just talk about compliance. They've been to take a broader look at how to differentiate you and make you sustainable in a mature market, in a market where your margins are being under pressure all the time, and also in a world that is changing the operating structure. I mean, just take a look at things and how they have changed over the last few years, colleagues, just in terms of how you order your food, your groceries. Look at how they've changed in terms of electric vehicles, and of course, artificial intelligence. And if you look at our website, you have got free access to a robot, of course, called the Ask Johnny robot. Maybe at the back end, I'll demonstrate it to you. And we've also launched the world first disciplinary inquiry robot, which has got massive traction across many of our clients. So the world is changing. Don't be left behind. Now, in bringing the year to a close, Krista and I discussed what would a topic be to end the year off with. And we sort of said, well, we've covered so many so many areas. Maybe what we should do at the end of this year, which is today, towards the end of the year, is let's take a look at the road less traveled. And I told Johnny that I was going to be presenting to you today, and he said, on what topic? And I said, the road less traveled. And he said, well, what do you mean by the road less traveled? And I said, well, unfortunately, it's going to be a bit boring. We'll try and make it exciting, but today's focus, colleagues, is on certain statutes and regulations that are not always front of mind. They are regulations and statutes that sort of often fall into the background. When you look at your service level agreements with your clients, when you look at your costings, when you look at your risk, when you look at your policies and procedures, there are a lot of laws and provisions in those laws that we do not focus on. And with more and more legislation coming through, you have to start looking broader, not only to comply, but to see where you can take away pain from your clients. Remember, your clients, if you can give them added value services that takes the necessity of them having to go and learn about it and address it, then of course you will be differentiating yourself. So today we're going to look at the road less traveled, an overview of the laws and regulations that are not front of mind, but which do hold significant impact. And I want to encourage you to try and figure out how you are currently addressing this, and secondly, what you need to change in order to optimize this particular aspect of labor law. So colleagues, the laws that I have selected to cover today, and don't worry, I'm not going to keep you for too long, but the laws that I have selected today to speak of are these ones in front of you. Each one of them, I will have a one slide and I will talk to you about the principles in terms of how it applies in the TES and workforce solutions environment. And I'm hoping that you will get value out of that. So we're going to start off with the POPI Act. Now, the POPI Act has obviously been around for more than 3 years, and I still find that most TESs and their clients have not got their heads around what it really means in terms of personal information and the processing of that. We're then going to go on to the Promotion of Access to Information Act in terms of the information that is held by your clients and by yourselves in respect of your temporary assignees and your candidates. We're then going to look at disciplinary codes. Is your disciplinary code up to date? What are some of the key provisions that need to be infused into your disciplinary code? Then we're going to talk about harassment. And of course, your temporary assignees would be defined as vulnerable workers in certain contexts because they're working on a third-party site, on your client site, and it could be argued that they are potentially more vulnerable to harassment. What does that mean for you from a compliance point of view and a preventative point of view? Then we move on to cybercrimes. And of course, we are moving deeper into the fourth industrial revolution. And I believe we're on the cusp of the fifth industrial revolution. We need to make sure that because data is the currency of today, we need to ensure that all our stakeholders are aligned to and understand what cybercrimes are, because they do carry criminal as well as civil and labor ramifications. And if one thinks of your regulations, your policies, your employment contracts, are you covering these issues? Some of you place people into environments where they've got access to personal information, where they need usernames and passwords, or where potentially they could divulge confidential information. Then I'm going to talk to the issue of, under the Labour Relations Act, the 2-week rule. I'll come back to that later on. But I'm going to talk about the 2-week rule and whether or not you are providing for that in your financials. The national minimum wage, I'm going to touch on that because that definition is about to be changed based on a review of the Quantum Foods judgment. Then the Employment Equity Act, and of course we're currently in the reporting season for employment equity. And one of the things that is a massive, massive area of concern is who reports on your TES assignees after 3 months. And secondly, where are they reported? Are they reported as temps or are they reported above the line? And that's going to have a massive impact on organizations going forward as we have to become more and more astute in managing employment equity and targets and strategies. Then parental leave, I'm going to touch on that very briefly. We see the Van Wyk case has been set down in the Constitutional Court. So very soon we're going to have a definitive outcome in terms of non-childbearing parents, as well as adoptive parents and commissioning surrogate parents. Then finally, the OSH Act. You know, the OSH Act, your clients often try and put you under obligations in terms of the Occupational Health and Safety Act. So colleagues, these are the statutes I'm going to be touching on. And as Lisa said, I hope you're not going to listen to this recording when you're lying on the beach. You need to take a break, but I do hope that it will be of some use for you. I don't know if you remember, if you're old enough, a band called Simple Minds. Well, Simple Minds had a song that I used to love, Don't You Forget About Me. And that's really what we're saying today. Don't forget about these laws, colleagues. They have got potentially a big opportunity, but also significant liabilities attached to them. So let's take a breath and start off with the Protection of Personal Information Act. Came into full force and effect in the middle of 2021. Now, remember, colleagues, the POPI Act tells you when you are allowed to process personal information, whether it be names, ID numbers, medical certificates, payroll information, disciplinary charges, whatever it is. You can only process personal information with consent, for contractual performance, if it is legally required, if it's in the legitimate interests of the data subject, or if it's a criminal investigation. And the reason I'm raising this is that as a TES, I want to ask you, how do you get consent from your assignees, from your candidates, in order to process their personal information? Do you write it into the employment contracts? Do you have a POPI policy? Is it fine print on an email? How do you get consent? And that is a critically important aspect because you are processing that information. And in addition to that, you are sharing a lot of that information with your client. And your client is sharing information with you. So very often you are sending your client name lists, you're sending your client confidential information about employees, you're sending the client their ID numbers, and your client's coming back to you and sending you their timesheets, sending you certain productivity and performance statistics. And what this means is that you and your client are both processing personal information about your assignees and your candidates. And that means, in terms of the POPI Act, that you and your client are operators. Now, an operator is a company or an organization that takes someone else's personal information and processes it in their environment. So, for example, an outsourced payroll or outsourced recruitment. That is an example, your medical aid scheme, where the medical aid is taking all your employee information and processing it. So the question I think I'm asking you under POPI is, firstly, what do you have in terms of your employment contracts? And secondly, do you have an operator agreement written into your service agreement with your clients? Because both of you are operators, and the POPI Act says it's got to be in writing, because the operator must confirm and warrant that it complies with the POPI Act. And if ever there's a breach, the operator has to notify the TES or the TS has to notify the client. The other area I want to touch on under POPI is personal information sent outside of South Africa's borders. Colleagues, there are TESs that are sending information outside of our borders to maybe their client's head office in Germany or in the United States or wherever. I came across one a few months ago where they're sending information to Swaziland and to Namibia. And what you have to do is you've got to make sure that those destination countries have got protections at least of the same level as that in South Africa under the POPI Act. Then we get to the issue of surveillance. There's not a week that passes where I get a call and say, John, are we allowed to install CCTV cameras here? What about when we sign in at the gate? What about this? What about surveillance? Well, surveillance, of course, is personal information. So if your client has got surveillance on its site, you've got to build the right for you to engage in surveillance through CCTV footage and video footage. You've got to embed that into your employment contract or into your POPI policy or into your privacy policy, or else you're going to have a problem when you try and enforce that. And then, of course, for you as a TES, this is a difficult one. And it's not the only law that requires this, but induction and refresher training. The POPI Act requires employers and responsible parties to do regular refresher training on POPI because the world doesn't stop changing. We are using WhatsApp to communicate. We're using Telegram. We're using social media platforms. We're using AI. We're using a whole range of other technology platforms. And you need to continuously make your assignees and your employees aware of the risks involved in those particular engagements and transactions. For example, when you send information or you're password protecting, do you have security, end user security? Do you have advanced encryption on your emails, and so on and so forth? Do you protect and back up your information? Do you have an incident response plan? So colleagues, I've summarized it there. You need to address POPI in your employment contracts, your disciplinary codes. So if an employee contravenes the POPI Act, what is your guideline sanction? Do you have a privacy policy that speaks to all of these dynamics, your POPI policy, and then, of course, you need an incident response plan. If you've been watching or rather reading News 24, you will see Standard Bank had a data breach recently in which various account holders with Standard Bank and customers' details were unauthorized accessed. And as a result of that, Standard Bank's got to advise the information regulator and has to advise each of the data subjects so that they can take the necessary steps to protect the information from identity theft, from fraud, from phishing, from potential danger of the individuals. So colleagues, that is the POPI Act. And I hope that I've at least sparked a bit of thinking in terms of the POPI Act. Well, the Promotion of Access to Information Act is very closely aligned to POPI, but the PIA Act is an act which enables people who are not data subjects generally to, in any case, access information that is held by any organization. So, for example, today I'm in Port Elizabeth and I'm just looking at the harbor, and let's say that you were an environmental rights group and you wanted to get hold of Transnet's environmental impact assessment because you believe that Transnet are destroying the infrastructure and the ecosystem rather in Port Elizabeth, then how do you do that? Well, you'd use the Promotion of Access to Information Act, and you would go onto their website and you would complete a form and you would require disclosure in terms of that document. In your world, it could be disclosure about a tender that was awarded. It could be disclosure about a costing framework. It could be disclosure around what you pay your staff. So the POPI Act enables the party seeking the information to apply for it to the information officer and then to follow a process and make a decision whether or not you will disclose that information. Now, if you refuse to disclose that information, then of course the person requesting the information can then go to court and get a court order if the court awards it. Now, the point I'm making here is, remember, you are holding information about your client and your client's holding information about you, and that's got to be contained in your Promotion of Access to Information Act list of documents that are open to be requested by third parties. So, colleagues, as I said at the introduction, these are laws that represent a road less traveled. These are things we don't always think about, but they do need to be addressed because they show your client you know what's going on, and they also protect you in the context of these provisions. Well, let's talk about disciplinary codes. When last did you have a good look at your disciplinary code? Colleagues, unfortunately, in many respects, labor law is being left behind. In many respects, our disciplinary codes are stuck in the third industrial revolution. So the first question I want to ask you around disciplinary codes is, whose code applies? Whose disciplinary code applies to your assignees? Is it your disciplinary code? Or do you say in the contract of employment that the client's rules and regulations, including their disciplinary code, applies? My personal view, colleagues, is that as a general rule, your client's disciplinary code would apply, because there's got to be equal treatment in respect of that. So if your client has got a sanction of a final written warning for arriving at work under the influence of cannabis or impaired, well, then you can't have a code that differs from that. So you need to decide how you articulate that in your contracts and how you deal with it. The next one is also to not forget to contract with your client that you are the human resources party and the labor relations agent, that you as the TES will deal with grievances and disciplinary inquiries and all related matters and disputes. But that's got to be a delegation of authority from the client to you to run with those particular areas. And then in your disciplinary code, in the various categories, is POPI and cybercrime represented in your particular disciplinary code? As I said, more and more of your staff are having access to systems. More and more of your staff have got access to stock-taking systems, to production systems. They've got access to systems that might hold personal information, or systems that require password protection or regular updating of passwords. Does your disciplinary code cover hate speech as a form of harassment, with the hate speech bill being published the day before elections this year? What about smoking? Does your disciplinary code extend to e-cigarettes as well as non-nicotine-based devices? And then finally, colleagues, your representation in disciplinary inquiries. Is the client's union representative allowed to have the right of appearance in a disciplinary or grievance inquiry, even though your employee, your temporary assignee, is not potentially a member of the union, or you haven't recognized that union? And then collective agreements between clients and unions. You know, after 3 months, do your assignees have access to the benefits of those agreements? Now, as you can see, there's a reason that we say we live in a VUCA world: volatile, uncertain, complex, and ambiguous, because the ambiguity of this is significant. Because on the one hand, they're your assignees, but they work on your client's premises. They're your client's collective agreement and recognized union, but they want to sit in on your disciplinary inquiries. You see, this is the consideration, and you need to have a clear policy in this regard. Well, I hope, colleagues, that this is, as I said, creating a bit of opportunity for you to revisit this and rethink this and to engage with your clients on these particular areas so they know that you're on top of it. This is a big concern to me, and I'll tell you why. So if you have not been listening, this is very, very important. Harassment has been covered in the Employment Equity Act, but also, colleagues, harassment has got its own code of good practice. As you know, the code of good practice on harassment, I'm sorry about the noise in the background. I'm actually going to just try and move. The code of good practice on harassment, colleagues, is a very, very important code, because what it does is it has got very specific requirements of organizations. Specifically, if you take a look on the screen, paragraph 8.1. Now, paragraph 8.1 paragraph 8.1, colleagues, of the code, I'm going to read it to you so you can see exactly what it says. It says employers are under obligation in terms of section 60 of the Employment Equity Act to take proactive and remedial steps to prevent all forms of harassment in the workplace. So what it's saying is the first thing that the code is saying is you cannot wait until the pawpaws hit the fan. You are under an obligation in terms of section 60. Now remember, section 60 of the Employment Equity Act, colleagues, says that if you as the employer cannot prove that you put sufficient policies, procedures, and training in place to prevent harassment from arising, you are vicariously liable for that harassment. In other words, colleagues, what I'm saying is that the code puts an obligation on you and says you, as the TES, will be vicariously liable if you cannot prove that you have taken proactive steps. Now, look at what it says in the second part of 8.1. It says this includes an assessment of the risk of harassment that employees are exposed to while performing their duties as far as is reasonably practicable. What are they saying there? They're saying here, and it's the second bullet point, harassment risk assessment. Colleagues, you are under a legal obligation to take proactive steps, to have a policy, to do awareness training, but further than that, to do some form of harassment risk assessment. Even if it's a survey where you put questions to your temporary assignees and it's an online survey and you say, have you ever experienced marginalization? Have people joked at your expense? These are the types of things that you need to ask of your temporary assignees so that they can respond to that, and you can then get a sense. You can get a sense of what the extent of the particular risk is that they are facing. And I'd love to see, if you chat in the chat box, how many of you have actually done a harassment risk assessment? How many of you do awareness training in terms of your particular assignees and their rights in terms of harassment? Because the POPI Act also, colleagues, requires regular awareness training sessions. So maybe, as I say, just in the chat box, what is your level of compliance? What do you think about what I have discussed with you? Let me go take a look at some of the comments. I've tried to move away from the noise. I am in a convention center, so I apologize. So Nicole, yes, thank you. Good morning to you as well. Lisa says, thanks for joining. Then, can you repeat the meaning of VUCA world? Absolutely, Nikki, it's volatile. uncertain, complex, and ambiguous. So volatile, of course, I saw an article the other day talking about the word perma-crisis. Perma-crisis. As its name suggests, we are in a world of permanent crisis. We literally are in a crisis mode. If it's not COVID, then it's artificial intelligence. If it's not artificial intelligence, it's natural disasters. If it's not natural disasters, then it is political issues, warfare issues, warfare across the globe, etc. So we truly, colleagues, we truly in a volatile, uncertain, complex, and ambiguous world. The opportunity for you, however, is to try and use that volatility to your advantage. In other words, you need to go to your clients and say, how are you responding to this? How can we help you? Can we co-design certain solutions that will help you going forward? So, colleagues, there we go. Let's just recap very briefly where we have come from. So we're looking at all of these laws that represent laws that are not front of mind, but are important in any case. The POPI Act, we've discussed the importance of you being an operator and entering into a written operator agreement with your client. The POPI Act, updating your disciplinary code, and then the code of good practice on harassment. There was a ShopRite case on that not so long ago where one of the female employees at ShopRite was trying to process an order online, and she was battling to get the order done. She then called a male colleague of hers, and the male colleague came and stood next to her and decided that he would slap the female colleague on the buttocks. So he smacked her on the buttocks, and long story short, it ends up in the labor court. And the labor court at that point was said to ShopRite, well, firstly, do you have a policy? Have you done awareness training? Have you done a harassment risk assessment, etc.? And unfortunately, this was a few years ago, ShopRite did not have all of that in place, and ShopRite was found vicariously liable for the act of the manager and fined as a result of that. Now, it's not the fine alone, colleagues, that worries me. Remember, under the Employment Equity Amendment Act, if your company has been a party to unfair discrimination, which includes harassment, you will lose your certificate of compliance. So that's the fourth bullet point on the slide. You risk losing your certificate of compliance under employment equity. So imagine if you lost your certificate of compliance and you can't tender for public sector work. Private sector clients will maybe exclude you from their tender processes. And then on top of that all, you might even have a problem being verified under management control in the BE scorecard. So this is serious, serious business. And I think this is something that's neglected potentially across the industry. Here's an example of a risk assessment that was done recently. We did across an organization. I'm just showing you that what a harassment risk assessment would look like. So this is a consolidation of results in this organization where the employees completed an online survey. Now, the most prominent risk was ostracism. In other words, excluding people, marginalizing them. Then in this organization, humiliation. People being humiliated in front of their colleagues, being spoken to with sarcasm, emotional abuse and constant personal criticism, abusive language. You see, colleagues, the code introduces a whole range of other types of harassment. And, you know, we don't always necessarily think that harassment is so broad. But if you found that you haven't taken steps to address this, then you could be vicariously liable. And then we can also see results per race and gender grouping. So my strong recommendation, colleagues, to show your clients, to show your assignees your commitment to their well-being, I would seriously recommend you take a look at that. Well, I don't know how many of you are placing people into jobs that require your assignees to access systems. Obviously, your own staff do a lot of work on CRM systems and on payroll systems and human resources information systems. But the Cyber Crimes Act is, colleagues, a very, very important law because we are dealing more and more with cyber crimes, and we're dealing more and more with aspects of data protection. Now, I want you to read the definition of cybercrime with me. A cybercrime is defined firstly as unlawful access. In other words, accessing a computer system or data without authorization. Now, for example, if I made a very, very simple example of this, is you using your colleague's Claude AI platform that they're paying for one user, but you are using their username and password unlawfully in accessing that particular system. That would be an example of unlawful access. Unlawful interception of data is the second one. In other words, you acquire or you view or you copy data without permission. How many times do we not use data and we make it available without permission? That is a cybercrime, colleagues. Unlawful interference, thirdly, with data, computer programs, or storage, or computer systems. So in other words, if you delete data, you make it inaccessible. For example, you hold people to ransom, or you're angry at your employer and you delete their particular data, or you impair the functionality. That's a cybercrime. You can end up in jail, colleagues, for up to 5 years for that kind of conduct. Then cyber fraud, representing the facts with the intention to defraud. And look at point 6, malicious communications. In other words, using digital technology and platforms to send threatening, intimidating, or offensive messages. So next time, do not push the send button if you've got offensive images, race, gender, sex, intimate images, or any forms of threats or harm or damage to property. That, colleagues, is a cybercrime. Theft of incorporeal property, in other words, proprietary information, and then password-related crimes. The unlawful sharing of passwords, the unlawful access to passwords and codes and similar data. And I can only imagine that cybercrimes are going to become more and more prevalent in the world we're in. I remember many years ago when I was within your industry, one of our companies in the group used to place a lot of bank tellers and people in the bulk cash centers. And suddenly you had syndicates emerging. You had very organized crime taking place in that environment. What we now see is it's moved into the digital space, and more of these offenses are happening in the digital realm. So I need you to please take a look at how you are addressing this, not only within your organization, but you need to go to your client and you need to say to your client, listen, will any of our staff be involved in using systems that could potentially entice them or result in them engaging in a cybercrime? Why don't we change track very quickly and talk about the Labour Relations Act? Today, colleagues, I'm not going to talk about dismissals. I'm not going to talk about strikes or lockouts, but I'm going to talk about parts of the Labour Relations Act that sometimes we don't always take into account and think of. How about the first one? Termination pay for assignees who've been assigned for more than 2 years, who earn below the threshold. In other words, colleagues, if you take a look at the Labour Relations Act, it says that if someone has been on a fixed term contract for more than 2 years, then in addition to giving them notice, when you terminate, if notice is due to them, you have to also pay them 1 week's termination pay per completed year of service. This is not severance pay, but it is a recognition of tenure calculation. And I'm just wondering if you're building that into your costings properly, or you are contracting with your client so that when the cost arises, then you can recover that money from your client. The second bullet point is, how do you calculate length of service? Now, the reason I'm asking that is if you look at the bottom right-hand side, the Basic Conditions of Employment Act in Section 84 says that for purposes of determining the length of an employee's employment with an employer for any provision of this act. So remember, the severance pay falls within the BCA. So it says when you're working out the duration of employment, previous employment with the same employer must be taken into account if the break between the periods of employment is less than 1 year. And that to me has been a big concern for many, many years, because you've got temporary assignees who've been working for you sometimes for decades. They've worked at BMW, they've worked at Nestle, they've worked at RTT, they've worked all over the place. And the break in employment has not been less than 12 months. Now the day comes when you cannot reassign them, or you don't find a new opportunity. And the question is, how do you determine their length of service? Now, remember, in the Basic Conditions of Employment Act, even though the client and the TES are jointly and severally liable, the BCA is not like the LRA. The BCA says the employer is the TES. So Section 84 applies to the TES. And I need you to just think about that and how you deal with that in terms of recognizing length of service. On the left-hand side, remember also, colleagues, Section 198A. So we're back in the LRA, and it says that after 3 months, you cannot treat the temporary assignee on the whole less favorably than an employee of the client. And I often wonder about equal treatment. I think we're very fortunate, colleagues, that trade unions have not made more of a fuss about non-remunerative issues like annual leave, sick leave, family responsibility leave, parental leave, funeral, pension, medical aid opportunities, study opportunities. You see, I think that we have to be cognizant that equal treatment is not confined to remuneration, but it's on terms of employment. And then, of course, Section 198D, which says you can differentiate in terms of treatment, but then it's got to be based on seniority, experience, length of service, merit, quality of work, etc., or any other justifiable reason. So, colleagues, those are just some areas in terms of the LRA and the BCA, which I'm concerned about, that we are not always alive to. And maybe you want to just let it be, let sleeping dogs lie, but I think it is important to be cognizant of this. Now, if you pay the national minimum wage to any of your assignees, you really, really need to listen now. Colleagues, the labour law review at NEDLAC has just been completed, and there are significant changes coming through around the Labour Relations Act, the Employment Equity Act, the Basic Conditions of Employment Act, and the Code of Good Practice on Dismissal. And we'll be running a webinar early in December in which Johnny Goldberg is going to take us through what these changes are that are pending. But one of the things that have been put to be proposed changes is a change to the definition of national minimum wage. Now, you'll remember the Quantum Foods judgment. Colleagues, the Quantum Foods judgment said that the national minimum wage can be calculated by looking at the basic salary of the person, and you can include guaranteed company contributions like pension funds, guaranteed bonuses like a 12th check, a 13th check. So the Labour Appeal Court said you can calculate the national minimum wage by including guaranteed payments other than salary. Well, of course, that set the cat amongst the pigeons, because the trade unions federations were very upset, and they said that was never the intention of the national minimum wage, to include incentive payments and pension fund contributions. So they have now proposed to exclude that and to amend the National Minimum Wage Act to exclude those types of payments from salary. Now, the impact of this would be that if you do have clients that you are providing a service to, you need to get in front of them sooner rather than later. You need to get in front of them and say to them, listen, how does this potential amendment to the National Minimum Wage Act definition affect you as the client? Because it could very well have an inflationary impact on wages. It could also have an impact on your margins. And I think you need to be proactive and say, well, how do we work this particular dynamic into it? Because I guarantee you, they will change the definition of the National Minimum Wage Act. Colleagues, please feel free to post any questions that you may have into the chat box. I'll also open up for Q&A at the end of the session. And also, a lot of these questions that I'm raising don't always have simple answers. It's more a case of making you alive to these particular areas. Well, colleagues, the Employment Equity Act and the Amendment Act, for me, the biggest challenge for you as a TES is Section 57. Now, Section 57 of the Employment Equity Act is very, very clear. It says that after 3 months, and this is not subject to the earnings threshold like the BCA, etc. It says that after 3 months, the client is the deemed employer for purposes of Chapter 3 of the Employment Equity Act. Now, if you look at the flow diagram on the bottom left-hand side, Chapter 3 talks about that entire value chain, electing committee members for EE committee, training them, having regular meetings, conducting a workforce profile analysis, barriers analysis, corrective measures, employment equity plans, consulting on the plan, and then, of course, as we now are doing, submitting the employment equity reports to the Department of Employment and Labour. So what Section 57 says is that for that whole proposition, the client is the deemed employer. So by implication, your client, in my personal view, and it sounds counterintuitive, but your client should be reporting your temporary assignees who've been placed on the client's premises for more than 3 months. And that's the issue here, colleagues. And it's a massive challenge from various aspects, because it skews your client's numbers. It provides a misrepresentation of exactly what the client's reality is. But that's what the Act says. And we can't just tear this page out of the Act and say, well, we don't like Section 57, so I'm just going to throw it out. So, colleagues, I'm not sure how you guys are addressing this, but it is definitely an area that is going to come under scrutiny. And I think inspectors are becoming more and more alive to this as they do their DG reviews, and they're going to be looking out for this technical compliance area. Well, colleagues, parental leave, you'll remember the Van Wyk case for those of you who can't recall. A gentleman, Mr. Van Wyk, his wife fell pregnant, and she runs her own business. She's an entrepreneur, and he worked for a company. So when she fell pregnant, she said to him, listen, why don't you go to your employer and tell them that you want 4 months maternity leave? Well, colleagues, you can imagine when you ask the employer for 4 months maternity leave, the employer almost fell off his chair in surprise and said, well, you're not going to get it because you're not bearing the child. So sorry, you can have 10 days, but you ain't having 4 months. Well, colleagues, of course, the Van Wyks took it all the way through to the High Court, and the court said that it was discriminatory. They said it's unfair discrimination because if you only allow the childbearing mother or surrogate mother the 4 months, if you only allow the childbearing parent 4 months, then you are perpetuating gender stereotypes, and you are also perpetuating the reality that the other partner might also be involved in rearing the child and caring for the child. You're also then ignoring adoptive parents, and you're also ignoring commissioning surrogate parents. So the High Court said 4 months should be available to everyone, whether you're a child bearer or not, whether you're adopting or not, whether you're in a commissioning surrogacy agreement or not. The only thing that had to be done was for that judgment to be, in inverted commas, confirmed by the Constitutional Court. So the Constitutional Court is currently this matter's on the way to the Constitutional Court for confirmation, and we probably have a final confirmation early next year. How does it affect you? Well, you're going to have to find out from your client whether or not they pay all or part of parental leave, in inverted commas, maternity leave. Because remember, equal treatment means that your employees, your temporary assignees, are on the whole treated not less favorably. So you're either going to have to work this into your service agreements, into your costings, or you're going to have to somehow get your head around this. Well, colleagues, I think this is the last slide that I wanted to cover today on the road less traveled. Just going to have a quick look. I'm just going to have a quick look in terms of the comments. Krista said she circulated an invitation to the session on labor law reforms to be done by Johnny. Excellent. Thank you, Krista. That's very, very important. Some sweeping changes coming through on severance pay, probation, dismissal rights, etc. So very, very important. So colleagues, with that in mind, I'll move forward to the very last theme for today. Now, this is the Occupational Health and Safety Act. Now, I remember when I worked in your industry, we used to get service level agreements from clients, and there'd always be a paragraph in that says, the TES indemnifies the client for any occupational health and safety related matters. The TES will take responsibility for compliance with the Occupational Health and Safety Act. And for me, that was non-negotiable. We would never, ever accept that liability. Why? Well, you are not in control of your client's premises. You are not operationally in control of your client's premises. You do not do health and safety inspections. You do not do health and safety meetings. That is your client's responsibility. In fact, you can see on the bottom left, it says that employer excludes a labor broker in section 1 of the Occupational Health and Safety Act. So colleagues, do me a favor, never, ever accept responsibility for occupational health and safety. Now, having said that, I also want to say that if you are running a functional outsourced contract, so you are not only providing the employees, you are also taking responsibility for output. If you are running a managed service provider, then obviously you are responsible for occupational health and safety in that context of your outsourced function. But if you are operating as a TES, you must never ever accept responsibility in any way for that. Also remember, you may not deduct money for protective personal equipment. There, section 23 of the OSH Act is very clear. It says employers cannot, number one, deduct money for PPE, point two, deduct for safety training, point three, deduct for medical surveillance, in other words, tests that are work-related, medical tests, entry and exit tests, pre-employment tests, and you may not deduct for any other health and safety measures required by the Act. The only exception is if the employee negligently loses or damages the uniform. So, colleagues, that effectively brings us to the end of this particular formal presentation in respect of the road less traveled. As I said to you at the beginning, I want to encourage you to visit our website, www.globalbusiness.co.za. The reason I'm saying is you'll see at the bottom right-hand side, there's the Ask Johnny chatbot. So if ever you have a question that you just want to make sure that you got the right answer, please go and use the chatbot. It's being trained continuously on labor law, on policies, and on all things related to human resources and employment relations. The other thing I want to extend an invitation to you is you'll see on our navigation bar, there are GPS bots. We've developed a disciplinary inquiry initiator bot and a chairperson bot, and I want to give you an invitation. If you're interested, we can do a demo for you. Free demo, takes 15 minutes, and we can demonstrate to you what is happening in this regard. We've got a massive uptake. It saves 60 to 70% of your time as an initiator or a chairperson. It's infinitely more accurate technically, and of course, colleagues, it is something that will give you the opportunity to focus on non-repetitive human-centric tasks. Colleagues, that brings us to the end of the session. I hope that it was informative, and I'm happy to take any questions that you might have. Thank you.
So, John, I don't know if we have any questions. If not, please go ahead and refer to John while we have him and his knowledge pack available. Krista, I see you may have a comment. I'm not too sure.
Yes, thank you, Kevin. John, there is a question from Natasha in the Q&A box, and then also in the chat box from Mohammed.
Natasha's question, I don't see it in the chat box. I can see Mohammed's one to go back to the slide on deeming, which I'll do. But maybe you can just share the question from Natasha.
Okay. If you place staff on a client's site and some staff, team leaders or site supervisors are perm staff, but with the TES just packed on clients' sites. Oh, it's a long question. Okay. Client wants us to sign a 37.2. Do we need to sign it? That's from Natasha. It's in the Q&A box.
Okay. So effectively, the question is, if you place people permanently, if I understand, on site, do you need to sign a Section 37.2 mandator agreement? The answer is no. The only time you sign a mandator agreement is if you are the outsourced service provider. But if you're operating as a TES, you never, ever sign responsibility for that. So it's only if you're doing a full shutdown, or you're building a construction site, or you may be, controlling an entire portion of a production value chain. But if you're acting as a TES, whether they're permanent or temp, you don't sign a Section 37.2. Mohammed, you wanted to go back to the 3-month deeming question. I've got it up on the screen. I don't know if you have a specific question. So I'll definitely add you to the Ask Johnny WhatsApp group. Crystal, I'm going to take a quick photo of that. And there we go. I'll ask our marketing team to add you to the Ask Johnny chat group. Thank you very much for that. So, yeah, Mohammed, I just think the issue of deeming post 3 months is a massive issue, even though we know that it doesn't mean that there's a transfer of the employment relationship. It does mean equal treatment. And, you know, thus far, trade unions and employees have been unsuccessful in litigating off the back of that. But I think the day is going to come where they'll ask for discovery of documents. They're going to ask you to make much more disclosure, and they're going to do a full reconciliation in terms not only of salary, but in terms of leave, in terms of other benefits like pension, medical aid, etc. So, you know, I am worried about that. I'm quite worried that that day arrives and it's going to be a massive issue. At least, though, they can't go back more than 6 months. Okay. They can't go back more retrospectively than 6 months. But even 6 months' salary is a massive, massive thing. And then, yes, I see there's some more numbers that I can add. Thank you very much for that. If you need anything else, you are welcome to contact me. I'm going to put my phone number in the chat box as well. And you are always welcome to WhatsApp me and we can have a chat. I think, Kevin, through you, maybe that's a wrap. Thank you for the opportunity, Kevin, to you and the team always. And I just want to wish you a blessed festive season if I don't speak to you before then. Thank you, Kevin.
Thank you very much, John. Once again, very enlightening and very deep presentation. I think the road that is less traveled is not necessarily the road that is untraveled, and it has as many potholes, if not more, than those other roads where we know generally where the normal issues are concerned relating risk, particularly risk in the test industry and the impact of other structures and other influences within that industry, due particularly because of our tripartite relationship with the client. We sit in an industry that is very different, very atypical, and that's why it's called atypical labor, to any other industry where there are bipartite agreements or bipartite employment relationships. So once again, John, thanks very much. I think you've enlightened us, and I think there's still so many other issues that we need to also maybe deal with in terms of the road less traveled, and maybe it should be another topic for some time during 2025. 2025 is knocking on the door. This will be our last meeting, and we'll definitely be pushing your doorbell, John, to come back and assist, come back and inform, because your presentations do add massive value, massive value. Once again, thank you. Thank you for sharing. And also just to our participants, other colleagues, thank you for your participation. And I'm sure that you've added value, can add value with the detail you've received today to your business. There's lots of questions to be asked of management. There's lots of questions potentially to be asked of your clients, and there's also a lot of questions to be posed in terms of your service level agreements you have with your clients. So maybe it's time before we get into the new year to take the service level agreements out, dust them off, and read them clause by clause, particularly with specific references, say, to Section 23 of the Yash Act, and also with regard to Section 57 of the Employment Equity Act. We can go on another half an hour at least with all the other sections that are of relevance. And this is why I say we would welcome John coming back next year, another webinar, also to once again relook at the road less traveled, and how we must sort out the risk issues which are contained in the so-called road potholes. Wishing you all a wonderful day and a beautiful season of Christmas, those who do celebrate this time of peace, and we will see you all hopefully after you've traveled safe and returned home from your holidays next year. I think our first meeting next year is in February. I'm sure, Krista, that you will communicate that to the members and to the colleagues, and also in terms of further discussion with John. Just once again, thank you, John, very much for your time and for the information, which is more than just worth sharing. It needs to be driven down to the lowest levels of our management teams in our industry. Thanks, John, and thanks everyone else, and bid you goodbye.
Thank you, everyone. We'll see you next year. Have a safe and restful festive season.